Professor of Law here at UCLA. He has the degrees BSL, LLB from the University of Minnesota, LLM, and Doctor of Science in Jurisprudence from Columbia University. Is a member of the Wisconsin and Minnesota bars. Before coming to UCLA, served on the faculty of Indiana University and the University of New Mexico. The aspects of the law which concern him in his research are the subjects of procedure and remedies. I take pleasure in presenting to you Professor John A. Bauman. John.
Professor Frankel, ladies and gentlemen, I feel at something of a disadvantage in coming before you, since our first lecturer was a professor of English, Red Marlowe, and our second lecturer was a professor of music, played the piano. But law professors have none of these talents. We simply read cases, and that's pretty dull as a performance before an audience. In any case, I must think of our image. Even ball players are doing it these days. And I would not want you to think that lawyers are unconcerned with aesthetics. For the truth of the matter is that Shakespeare and his plays have always had a particular fascination for members of the legal profession. For one thing, what lawyer can afford to neglect the author of that timeless sentiment, "The first thing we do, let's kill all the lawyers"? For another, we lawyers have decided to claim Shakespeare as one of our own. A consideration of Shakespeare's plays, several centuries after his death, led a number of otherwise sensible people to conclude that the author of the plays was most certainly a lawyer. Mark Twain, for one, was sure of it. Lord Campbell declared that there was sufficient evidence on the point to get to a jury. And Stephen Leacock, amused by it all, wrote that it could at least be said that the playwright had the intellectual training of a lawyer, for didn't he write in Macbeth, "What is there in it for me?" There is certainly one thing lawyers may legitimately claim. Shakespeare's original patrons were members of the Inns of Court, and two of his plays, Twelfth Night and A Comedy of Errors, were presented in the halls of the inns. These unique institutions, described by Ben Jonson as the noblest nurseries of humanity and liberty in the kingdom, were the homes of societies of practicing lawyers and students of the law. Organized along the lines of medieval universities, with benchers and readers, their membership included sons of knights, barons, and the greatest nobility of the kingdom. It will be recalled that Shakespeare attributed membership in the inns to both Prince Hal and the Plantagenets, while Falstaff and Justice Shallow were made members of the Inns of Chancery. Solicitors, whom Hudson described as a new breed, sprung up like the grasshoppers of Egypt to devour the entire land, and attorneys, mere business representatives of their clients, were excluded from membership in the inns as persons of an inferior nature. In addition to getting a legal education, Fortescue tells us that students at the inns learn singing and dancing and such other diversions and accomplishments, which are called revels, as are suitable to their quality. When Sir Andrew in Twelfth Night stated, "I delight in masks and revels, sometimes altogether," he indicated that these occasions sometimes degenerated into scenes of riotous hilarity. Such festivals were undoubtedly the Elizabethan counterpart of the annual cocktail party at the State Bar Association convention, where more than one lawyer has enjoyed himself sometimes altogether. Patrons of the arts, avid playgoers, men of affairs, members of the Inns of Court formed, in Maitland's words, a reasoning and reasonable element in the English nation. They played a principal part in the events which shaped the English law. Out of the unpromising material of the formulary system, these most unlearned of learned men developed a law of contracts, freed land of restrictions on alienation, and reconstructed the entire land tenure system of the kingdom. With this ungodly jumble, they defied and confounded the despotism of king and lord protector, while the customary law of Germany and France was swept away by the 3 R's of the Reformation, Renaissance, and Reception. The common law of England, a national law, taught in the Inns of Court, stood fast on its foundations. It may truly be said that law schools, then as now, make tough law. The impact of the Renaissance on English law should not, however, be minimized. Previous lecturers have told us of the impact of the new learning on art, on music, and on literature. For the law, these events were equally momentous. The medieval idea that law was based on the will of God, binding on all, and rendering justice to each according to his due, was challenged by the modern, the Machiavellian idea that law was nothing more than the will of the sovereign. In England, the precise issue raised was whether the monarchy was to be absolute, a theory pursued in its most extravagant form by James I. His extreme ideas of the divine right of kings precipitated a constitutional crisis of the greatest magnitude. In this controversy, those opposing the crown relied on what was essentially a medieval idea, the supremacy of the common law, and they supported this position with precedents drawn from the ancient records and the plea rolls. Their champion was Sir Edward Coke, Attorney General and later Chief Justice of both the Common Pleas and King's Bench Court, who had a sort of mystical reverence for the common law. He could, with absolute seriousness, describe Littleton's book on tenures, written in bad French, as the most perfect and absolute work that was ever written in any human science. Today he is remembered by historians as the parliamentarian who exacted from Charles I his assent to the Petition of Right, and by law students as the author of Coke on Littleton, a book over which Justice Story wept and about which Webster wrote, "No boy under 20 should attempt to read it." On the side of the royal prerogative stood Sir Francis Bacon, lawyer, philosopher, man of letters. One of the greatest intellects of his age, his great philosophical work, Novum Organum, was contemptuously dismissed by Coke with a couplet: "It deserves not to be read in schools, but to be freighted in a ship of fools." After many trials and disappointments, Bacon finally realized his ambition to be Lord Chancellor of England, only to be charged, tried, and convicted of accepting bribes and sent to the Tower in disgrace. Only 2 of the controversies that arose from the opposing views of these 2 great rivals can be recounted here. The first involved the question of the relationship between the Court of Chancery and the courts of the common law. The courts of the common law, King's Bench, Common Pleas, and Exchequer, each had a distinctive jurisdiction of its own, and by the use of fictions, a concurrent jurisdiction in most civil actions. The law administered in those courts had been crystallized in rigid forms in 1285, and the procedure was exceedingly technical and fraught with peril. To correct the deficiencies in the common law, resort was had to the residuary jurisdiction, which was always thought to remain with the king. Ultimately, 2 new courts were developed, the Court of Chancery and the Court of Star Chamber. The Star Chamber administered a sort of criminal equity, punishing routs and riots jury tampering, frauds, and libels. You will recall that it was here that Justice Shallow threatened to take Falstaff. "I'll make a Star Chamber matter of it," he said. The Chancery Court, on the other hand, provided relief in civil cases where the remedy at law was not adequate. Its procedure, modeled after canon law, was summary and expeditious. In the words of Lord Chancellor Ellesmere, its office was to correct men's consciences. A favorite way of expressing its jurisdiction was by a couplet attributed to St. Thomas More. Said he, "Three things are helped in court of conscience: fraud, accident, and things of confidence." In the exercise of that jurisdiction, it was the Chancellor's practice to prohibit the enforcement of claims or judgments based on fraud. Cook, while Chief Justice of the King's Bench, determined to put a stop to this practice, relying on the statute of praemunire as authority for this position. This statute seemed to have nothing to do with the problem, having been originally enacted to prevent appeals from English courts to the Pope. The case which precipitated the actual crisis was an interesting one on its facts, and from the standpoint of Cook could hardly have been worse. An action was brought in the King's Bench on a debt. Defendant had a witness who could give testimony that the debt had actually been paid. This witness was enticed into an adjoining tavern, and a bottle of sack was ordered for him. When he had put this to his mouth, the perpetrator of the fraud returned to the court, arriving at the moment when the witness was called. When the witness failed to respond, the defendant sought a delay. But this was denied when the defrauder swore that delay would be in vain, for he had just left the witness in such a state that if he were to continue in it for a quarter of an hour longer, he would be a dead man. When the facts of this fraud were made known to the Chancellor and sued for an injunction, the enforcement of the judgment was, of course, prohibited. Cook, who in our charity we must assume was unaware of the facts, then sent for the plaintiff, and he recommended that he prefer a writ of praemunire against the party who had filed the bill in Chancery, and his solicitor as well. His next step was to attempt to obtain an indictment from the grand jury, which was charged at the Hillary term in 1616. The jury refused to cooperate, returning instead a verdict of ignoramus. They didn't know, in other words. Even after being sent back with threats, told by the bailiff that the Lord Chancellor was dead and that there was nothing to fear, and polled in order to make them stand up and vote in the presence of Cook, they refused to change the verdict. Cook was very angry, and he took the occasion to warn lawyers, "Whoever shall put his hands to a bill in an English court after a judgment at law, we will foreclose him forever speaking more in this court. Some must be made an example, and on whom it lighted it will fall heavy. We must look about us, or the common law of England will be overthrown." During all of these events, the Chancellor, Lord Ellesmere, was confined to his bed and was thought to be dying, making Cook's efforts seem even more reprehensible. Sir Francis Bacon, having already advised the King that Chancery was the court of his absolute power, informed the King of these events. Meanwhile, to everyone's surprise, Ellesmere recovered, and he prepared a case which he laid before James, concluding with the question whether upon an apparent matter of equity, which the judges of the law by their place and oath cannot meddle with or relieve, if a judgment once be passed at common law, the subject shall perish, or the Chancery shall relieve it, and whether there be any statute of praemunire or other to restrain this power in the Chancellor. The King referred this question to the Attorney General, the Solicitor General, the King's Sergeants, and the Attorney General for the Prince of Wales, which ought to be a sufficient legal talent, and they made a report to him that the statutes of praemunire did not apply to such a case, and that according to reason and many precedents, the Chancellor had the jurisdiction which he had exercised to examine the judgment of the courts of common law and to stay execution if he should find they had been obtained by fraud, by which the common law courts could not afford a remedy. James, however, in deciding this controversy for the Chancellor, rested the decision on the royal prerogative, asserting that it pertained only to his princely office to judge over all judges and to discern and determine such differences as at any time might arise between its several courts touching their jurisdiction, and the same to settle and determine as he and his princely wisdom should find to stand most with his honor. To ensure that the issue of jurisdiction was finally settled, the royal decree was ordered to be enrolled in the Chancery Court. Coke submitted, and during the short remainder of his judicial career, offered no further resistance to such injunctions. But in his third institute, having been convinced against his will, he again denied the jurisdiction of the Chancellor, maintaining that it was contrary to 27 Edward III. The decision in this controversy had a lasting effect on the development of English law. It determined conclusively that in cases of conflict with the common law, the equity rule would prevail. The significance of this will be recognized when it is recalled that the Chancery Court, unlike its sister court, the Court of Star Chamber, remained until 1873 as an enduring institution. Although a prerogative court, just like the Star Chamber, Chancery created for itself a legitimate area of jurisdiction, the enforcement of uses and trusts, and it was unthinkable for men of property to permit the abolition of a court whose jurisdiction so closely affected their interests. A much more serious controversy arose when James I, that learned but foolish monarch, asserted that he was entitled to rule as an absolute sovereign, and that he might judge whatever cause he pleased in his own person, free from all risk of prohibition or appeal. This assertion was made in response to the habit of Coke of issuing writs of prohibition from King's Bench to the various prerogative courts. To discuss his proposition, James summoned to Whitehall the common law judges and the ecclesiastics. For the king, Archbishop Bancroft argued, "Your Majesty may take what causes you may be pleased to determine from the determination of the judges, and determine them yourself. This is clear in divinity. Such authority doubtless belongs to the king by the word of God and scriptures." In response to this argument, Coke declared, "By the law of England, the king in his own person cannot adjudge any case, either criminal as treason, felony, or so forth, or betwixt party and party concerning his inheritance or goods. But these matters ought to be determined in some court of justice." James then argued that the English law was founded upon reason. "If that be so, why have not I and others reasons as well as you judges?" To this Coke replied at some length, stating in a passage which I think law students should note, that the law was not founded on natural reason, but by the artificial reason and judgment of the law, which was an art it required great study and experience to master. He concluded by saying, "The law is the golden metwan and measure to try the causes of your Majesty's subjects, and it is by the law that your Majesty is protected in safety and peace." In a great rage, James said, "Then I am to be under the law, which it is treason to assert." And then we have the famous reply of Coke. "Thus wrote Bracton, that the king should not be under man, but under God and the laws." The king was described as being very much offended. Some accounts say he had bended fist, offering to strike Coke, and that Coke, perceiving this, fell flat on all four. After the passage of considerable time and several revolutions, this controversy over the supremacy of the common law was ultimately resolved by the distinctive English doctrine that the prerogative was subject to certain limitations, and that the king and parliament had powers which he lacked when he acted alone. The importance of this distinction is apparent. By preserving the medieval idea that the sovereign was under law, the threat of despotism by absolute monarchy, or its modern equivalent, the police state, was averted. As might be expected, constitutional crises such as these over the extent of the royal prerogative were too delicate a subject for a playwright to consider. Instead, the law which Shakespeare propounds so profusely, and to which Lord Campbell could find neither demur, nor bill of exceptions, nor writ of error, is principally property law. This is to be expected, since the common law itself has accurately been described as the law of property. Meum et tuum, mine and thine. These are the great words of the common law, said Cook. Moreover, Shakespeare was familiar with this law, as were most of his contemporaries. The son of a litigious father who had participated in 50 lawsuits in 40 years, Shakespeare was himself a tenant, purchaser, and mortgager of land, and lest we forget, a testator who bequeathed to his wife his second-best bed. Thus it is not surprising to find references to property in the plays of Shakespeare. We read of a man who will sell the fee simple of his salvation, and of a kiss in fee farm, of leases of short-numbered hours, of enclosures and commons. Jack Cade threatens to turn all the realm into a common, but the maid of honor in Love's Labor Lost is more moderate. In denying a courtier's request to grant him pasture, she replies, "Not so, gentle beast, my lips are no common, though several they be." One of the major problems of the law of property at this time was the promotion of free alienability of land. By the statute de donis, it was possible to create an estate in land to last as long as there were lineal descendants of the grantee. The device of entailed estates, as it was called, had a particular appeal to the nobility, since it was designed to secure and maintain family fortunes which were then based on land. Incidentally, shrewd Napoleon, at a later time, advised his brother to secure the throne of Naples by this very device. Since Parliament refused to repeal the statute, the common law lawyers devised a scheme for barring entails by collusive lawsuits called fines and recoveries. The first decision upholding such proceedings was rendered in Tarleton's case in 1472, and the last of the series, Mary Portington's case and Chudley's case, were decided in Shakespeare's time. Over this period of time, conveyancers sought some method to avoid a recovery, much as a modern tax lawyer looks for loopholes in the tax law. All of these attempts were struck down. The last, Chudley's case, was argued by Bacon, and he was so proud of his argument that he had it published under a separate cover. So important did lawyers regard these proceedings that the Chief Justice of the Court of Common Pleas himself reproved a barrister who dared to criticize them, stating, "He was not worthy to be of the profession of law who dares to speak against common recoveries." To the general public, however, these proceedings were as amusing as they were well known. They involved an ouster of the plaintiff by a fictitious person and a voucher of warranty by a straw man, usually the court crier. Shakespeare took full advantage of the humorous aspects of these proceedings, introducing them into several of his comic scenes. Thus, in The Merry Wives of Windsor, one of the wives establishes the profligacy of Sir John Falstaff by saying that the devil has him in fee simple with fine and recovery. In the Comedy of Errors, Dromio of Syracuse refers to the difficulty experienced by a bald man who desires to recover his hair. Antipholus asks, "May he not do it by fine and recovery?" "Yes," says Dromio, "to pay a fine for a peruke and recover the lost hair of another man." Hamlet, in the speech in the churchyard over the supposed lawyer's skull, fires off a whole volley of puns on the same point. Is this the fine of his fines and the recovery of his recoveries, to have his fine pate full of fine dirt? One other well-known property case decided at this time should be mentioned, not because the decision had any lasting significance, but only because it is so famous. This is the rule in Shelley's case, decided in Shakespeare's time, plaguing law students ever since. It commenced as a simple case of trespass in the Court of King's Bench, but it was removed by command of Queen Elizabeth to to the Exchequer Chamber, so great was the interest in its outcome. Now, without going into all the technicalities, the decision of the case rested on the construction to be given to a grant to Edward Shelley for life, remainder to the heirs male of his body. The precise issue was whether the words heirs male of his body designated the person who was to take upon the death of Edward, in which case they were called words of purchase, or whether they determined the duration of the estate, in which case they were called words of limitation. The case, argued and won by Sir Edward Coke, established the rule that in such a grant the words heirs of his body were words of limitation, so that the ancestor had an estate of inheritance which passed to his heir by descent rather than purchase. The case was so well known, and the distinction was so clearly drawn, Cook's report of the case contrasting words of purchase with words of limitation more than 100 times, that the legal meaning of these words became familiar to the general public. It is therefore not surprising to find Shakespeare making use of the distinction in his plays. For example, in Henry IV, when the king tells his son that the crown, which in me was purchased, falls upon thee in a more fair sort, he meant that the crown had come to him by conquest, but that his son took it by descent. When Caesar in Antony and Cleopatra described Antony as an abstract of all faults, Lepidus excuses him by saying that Antony's faults are heredity rather than by purchase. In the case of our last Antony, Richard Burton, I suppose we would have to say that his faults are by purchase rather than heredity. The criminal law was another source from which Shakespeare freely drew. He lived in lawless times when the entire power of the state had to be mustered simply to preserve life and property. As Bagehot observed, a boy reading Ivanhoe wishes he lived in those times only because he assumes that he would have all the advantages of civilization and a great deal of fighting besides. Shakespeare knew better. When he wrote, "There is a law in each well-ordered nation to curb those appetites that are most disobedient and refractory," he accurately reflected the felt need of his age for law. A vigorous prosecution of the criminal law could be expected under such circumstances, and the trials and executions became a form of public recreation. The ferocity of the punishments were notorious even for those times. There were said to be as many as 800 hangings in one year, and there were innumerable cases of mutilation by nose slitting or ear cropping. In treason cases, the audiences were treated to an additional thrill, since the victim was drawn and quartered as well as being hung. By the time Shakespeare was writing his plays, a system of criminal procedure far different from earlier times had evolved. Instead of the old criminal appeal, a sort of private prosecution, indictment by grand jury had become firmly established. The jurors of the 100 met to report to justices of the peace at quarter sessions, much as in earlier times they had reported to the king's justices on ire. Thus the words Defoe wrote are true. The meanest English plowman studies law and keeps thereby the magistrate in awe, will boldly tell them what they ought to do, and sometimes punish their omissions too. Once imprisoned, the prisoner was kept in secret and was interrogated, sometimes after torture, which Fortescue said was the road to hell. There were no rules of evidence and no confrontation of witnesses. As Cook stated, trial was by jury, not by witnesses. But in order to try a man by jury, by the voice of the country, rather than by ordeal of fire, of hot water, of the cursed morsel, wherein was heard the voice of God, the accused had to consent. Thus the accused was asked, "Culprit, how will you be tried?" And he was expected to reply, "By God and my country." Since conviction of a felony resulted in a forfeiture of property, some of the accused were poor sports and refused to speak, standing mute. This posed a dilemma, since the ordeal had long ago been abolished by the Pope, and trial by jury required consent. The solution, so typically medieval, was to force the prisoner to consent, and the device chosen for the purpose was pressing, the infamous peine forte et dure. The prisoner was placed between boards in some low, dark room, and weights were placed on his naked body. And, in the words of the old formula, he was given worse bread and water, and no bread on the day he had water, and no water on the day he had bread. Shakespeare was well aware of this barbarous custom and makes several references in his plays to being pressed to death. The one humorous reference made is in Troilus and Cressida, where Pandarus promises the lovers a bed and tells them to press it to death, since it shall not speak of their pretty encounters. After a plea of not guilty, the prisoner was held for trial either before one of the king's justices on assize, or in cases involving lesser offenses, before the justices of the peace at quarter sessions. Originally, only justices of the peace with some legal knowledge, who were described as of the quorum, sat at the quarter sessions, but it became the practice for all justices to be described as of the quorum, with legal knowledge being supplied by a clerk. Thus we see Justice Shallow described as follows: in the county of Gloucester, Justice of the Peace and Quorum, meaning, of course, of the quorum. He is then further described as Custollarum and Rotalorum, which is apparently a reference to the fact that the principal justice was the keeper of the records, hence Custos Rotalorum. Justice Shallow is traditionally thought to be a caricature of Sir Thomas Lucy, a member of an ancient Norman family, who was said to have had Shakespeare whipped for deer stealing and ultimately banished from the county, as it was said, to his great advantage. Shakespeare also had a lot of fun with the Lucy family coat of arms, which consisted of luces, or pike. He has the Welsh parson pun on the word loose by declaring, "A dozen white louses do become an old coat well. It is a familiar beast to man, and signifies love." Trial in these courts was, of course, by jury, and originally some members of the indicting jury were also members of the petit or trial jury. If the indicters found that the indicted man was innocent, they themselves were then placed in prison. Needless to say, that made it very difficult to arrive at a disinterested verdict. Eventually, a challenge to a juror was allowed, and by Shakespeare's time, the theory was a jury of impartial men. The jury was, nevertheless, easily intimidated by wealthy and powerful nobles, which was one of the reasons why the Court of Star Chamber was developed. Now, in addition to their problem with powerful nobles, they were also subject to an accusation of a false verdict, which was brought by a proceeding known as an attaint. If the verdict was demonstrably false, they were then punished. For example, here is one: all of the first jury shall be committed to the king's prison. Their goods shall be confiscated, their possessions seized into the king's hands. Their habitations and houses shall be pulled down. Their woodland shall be felled. Their meadows shall be plowed up, and they themselves forever thenceforward be esteemed in the eyes of the law infamous. Indeed, the lot of a juror in those days was not a happy one. The most spectacular trials of this particular period were, of course, the treason trials. Motivated by the twin fears of Spain and Rome, a sort of Elizabethan equivalent of Russia and communism, such leading members of society as Essex, Southampton, Shakespeare's patron, and Raleigh found themselves cast in the role of leading characters in these performances. They were all given a trial by their peers, with Cook prosecuting for the crown. The trial of Sir Walter Raleigh is particularly well known and is regarded as a permanent disgrace to the English bar. The evidence that Raleigh intended to destroy the king and his children was insufficient even by the loose standards that prevailed in those times. Cook relied chiefly on epithets in detailing the charge, calling Raleigh the horriblest traitor that ever lived and worthy to be crucified with 1,000,000 torments, the absolutest traitor that ever was, and the most vile traitor that ever lived. And if that wasn't bad enough, he was described as having an English face and a Spanish heart. To all this, Raleigh's response was that Cook's words could not condemn him, and that it was no concern of Raleigh if Lord Cobham, his co-conspirator, had done wrong. Cook's reply was, "All that he did was by thy instigation, thou viper, for I thou thee, thou traitor." The use of the word thou was at the time a common way of conveying an insult. Cook continued in this vein until finally the commissioners themselves were so shocked that they rebuked him. "Be not so impatient, good Mr. Attorney. Give him leave to speak." Cook replied, "If I may not be patiently heard, you will encourage traitors and discourage us. I am the king's sworn servant and must speak." Thereupon, as the recorder relates, Cook sat down in a chafe, and he would speak no more until the commissioners urged and entreated him. After that, he got up and repeated it all over again, denouncing Raleigh, saying, "Thou art the most vile traitor that ever lived. I want words sufficient to express thy viperous treason." Of course, there was a verdict of guilty, but the public feeling was so outraged that the sentence could not then be carried out. Now, Cook's distaste for poets and playwrights was well known. He regarded them as the most worthless of mankind and thought they ought to be treated as vagrants. They ought to be kept in stocks and whipped from tithing to tithing. Shakespeare is believed to have retaliated by interpolating into Twelfth Night a parody of Cook's charge against Raleigh. In urging Sir Andrew to challenge Cesario to a duel, Sir Toby Belch advises him as follows: "If thou thou'st him some thrice, it shall not be amiss." The resulting challenge which Sir Andrew composes contains the following passage: "Whatsoever thou art but a scurvy fellow. Wonder not why I do call thee so, for I will show thee no reason for it." The congratulations of Sir Andrew's companion to this challenge contain the following passage: "For it comes to pass oft that a terrible oath with a swaggering accent sharply twanged off gives manhood more approbation than ever proof itself would earn him." The best parody of a legal decision, however, is to be found in Hamlet. In that play, the decision in Hales versus Pettit is made the basis of an amusing discussion between the two gravediggers. To understand the scene, it is necessary to briefly recount the duties of the coroner, one of the oldest of the royal officials. The coroner was originally the keeper of the pleas of the crown, and as such it was his duty to hold inquests to determine the cause of death. The primary purpose of this inquest was to protect the king's revenues, since if the cause of death was murder and the murderer had fled, all his goods were forfeited to the king. Moreover, if death was by suicide, which was itself a felony, not only was there a forfeiture, but in addition, the body was denied a Christian burial and was instead buried at a crossroads with a stake driven through it. It is this latter situation which was involved in Hales versus Pettit. Sir James Hale had been imprisoned in connection with a plot to place Lady Jane Grey on the throne, but thereafter he was released in pardon since he had nothing to do with the case. So frightened was he by these proceedings that he went out of his mind, and after first attempting to commit suicide by the use of a penknife, he drowned himself by walking into the river. At the time of his death, he was possessed for years of a large estate jointly with his wife, who survived him. Upon the supposition that the estate was forfeited, the Crown transferred the property to one Pettit. After entry, Pettit found himself the defendant in a suit of trespass brought by Margaret the widow. She claimed that her right of survivorship sprang up immediately after Sir James' death and took priority of the forfeiture. The issue thus was whether or not the wrongful act of suicide preceded James' death in point of time, so that the forfeiture occurred before the estate was divested and passed to his wife. The lawyer for Margaret, the plaintiff, argued that there could be no felony until the death, and thus, upon the completion of the wrongful act, the death, the estate had already been divested and was in Margaret, and therefore there was nothing to be forfeited. Now, for the defendant, Sergeant Walsh argued as follows. It sounds something like Gracie Allen. It says, the act consists of three parts. The first is the imagination, which is a reflection or meditation of the mind, whether or not it is convenient for him to destroy himself, and what way it can be done. The second is the resolution, which is a determination of the mind to destroy himself, and to do it in this or that particular way. The third is the perfection, which is the execution of what the mind has resolved to do. And this perfection consists of two parts, namely the beginning and the end. The beginning is the doing of the act, which causes the death, and the end is the death, which is only a sequel to the act. And of all the parts, the doing of the act is the greatest in the judgment of our law, and it is in effect the whole and the only part that the law looks upon to be material. For the imagination of the mind to do wrong without an act done is not punishable in our law. Neither is a resolution to do that wrong, which he does not, punishable. But the doing of the act is the only point which the law regards, for until the act is done, it cannot be an offense to the world, and when the act is done, it is punishable. Then here the act done by Sir James Hales, which is evil and the cause of his death, is the throwing of himself into the water. The death is but a sequel thereof, and this evil act ought some way to be punished. And if the forfeiture shall not have relation to the doing of the act, then the act shall not be punished at all. For inasmuch as the person who did the act is dead, his person cannot be punished, and therefore there is no way else to punish him but by the forfeiture of those things which were his own at the time the act was done. And the act was done in his lifetime, and therefore the forfeiture shall have relation to his lifetime, to that time of his life in which he did the act and took away his life. That's right from the report of the case. Well, the case was decided for the defendant on this plea, the court announcing the following profound judgment. Sir James Hales was dead, and how came he to his death? It may be answered by drowning. And who drowned him? Sir James Hales. When did he drown? In his lifetime. So that Sir James Hales, being alive, caused Sir James Hales to die. And the act of the living was the death of the dead man. And then for this offense it is reasonable to punish the living man who committed the offense and not the dead man. Well, in Shakespeare's parody of this case in Hamlet, Ophelia, like Sir James Hales, had lost her reason and committed suicide by drowning. Over her grave, the first gravedigger asked his companion whether she ought to have a Christian burial. His comrade says yes, as the coroner sat on her and found it so. Not being satisfied with this answer, the first gravedigger subdivides the subject in the manner of Sergeant Walsh. For here lies the point. If I drown myself wittingly, it argues an act. And an act hath three branches. It is to act, to do, to perform. Argal, she drowned herself wittingly. He then continues, mimicking the judgment of the court. Here lies the water, good. Here stands the man, good. If the man go to this water and drown himself, it is willy-nilly he goes. Mark you that. But if the water come to him and drown him, he drowns not himself. Argal, he that is not guilty of his own death shortens not his own life. The second gravedigger then asks, but is this law? And the reply is, aye, marry, it is. Crowner's Quest Law. Well, I have one other case that I'd like to mention to you because it provides an interesting commentary on the morals of the age. This case involved Chief Baron Manwood of the Exchequer Court. He learned that his son had disposed of a gold chain to a goldsmith named Underwood. and sending for the goldsmith, bullied him into handing over the chain, which Manwood put into his pocket and refused to give back. The goldsmith complained to the Star Chamber, with the result that there was a sensational case, which some commentators say is alluded to in the Comedy of Errors. The letter from the Privy Council addressed to the chief baron stated that they were satisfied upon the oath of divers persons that the chain was bought lawfully at open market, and likewise you got the chain into your hands by means of threatening speeches used by you unto the said Underwood to send him to the Marshalsea, having purposely a Marshalsea man by you with a tipstaff, whereby the poor suppliant was terrified and chose rather to deliver the chain to you than to endure the charges and other inconveniences of imprisonment. The council went on to censure Manwood, told him it was a very foul example to set for the rest of his calling. They required him either to deliver up the chain or, as an alternative, to appear before the council and explain why he had not done so. Soon after the occurrence of this case in 1594, the Comedy of Errors was acted in Gray's Inn Hall at the Christmas revels. One of the entanglements of the plots, you will recall, turned upon the resemblance between two sets of twin brothers, and the mistake in delivering of a gold chain to one of the pair of the twins by the goldsmith of Ephesus. Out of this incident sprang a whole series of misunderstandings. While the germ of this incident came from other sources, one can imagine how an audience of lawyers at Gray's Inn Hall in 1594 would have been amused by this allusion to the then celebrated case of Underwood versus Manning. Well, I hope that this account of some of the legal events of Shakespeare's time has proved interesting and maybe even amusing. I hope even more that it conveyed to you in some slight measure the method of evolution of the common law. For the common law, while always retaining its continuity, nevertheless constantly changed to meet new challenges and new conditions. Pragmatic rather than theoretical, it had, in Maitland's words, sound instincts and muddles along to convenient conclusions. But I would like to close with the words that Cook used in the conclusion of his institutes. And for a farewell to our jurisprudent, I wish unto him the gladsome light of jurisprudence, the loveliness of temperance, the stability of fortitude, and the solidity of justice. Thank you.
Does anyone wish to ask Professor Bauman any questions? Ma'am?
Well, they were picked from the county. They had to be men of the county, freeholders of the county. I don't know what in any particular manner they had to do it, in any particular manner that the selection was made, except that they had to be in the vicinity. Of course, there is a long history. Originally, they had to know the facts, and then ultimately they had to have the kind of mind that Belli was looking for in Dallas, knowing nothing about it. So it's very difficult without pinpointing any particular point of time.
Sir?
As the professor knows, in the American Bar Association Journal a year or two ago, they ran a series of articles on whether Shakespeare could have written the plays, particularly in those matters relating to legal subjects. And it was thought that perhaps it was the Earl of Oxford who was the author of Shakespeare's play. Now, where did Shakespeare get his knowledge of the law to be so proficient?
I don't think that he had any particular professional knowledge of the law. If you look at the cases, if you look at the plays, I can't get over my inbred habits. There's no mention in the plays of any of the forms of action. There's no mention of any technical kind of pleading. All of the references that he has are the kinds of things that anybody would know. When you look at the comedies, why would he use such expressions as words of purchase if nobody in the audience knew them? What would be the sense of having a joke on fines and recoveries if that was something exclusively professional? It stands to reason that the things that he was using were things known by his audience. I really, in looking the thing over, could find no reason to believe that he had to have training as a lawyer in order to write these plays. He was, after all, on the top of everything else, a genius. And there isn't any reason why he wouldn't be able to pick up these matters. Now, let me say one other thing. They say that the only person who is more unreasoning than a Baconian is a man who argues with him.
Are there any further questions? Then I will remind you that number 4 of our series, Religion in Shakespeare's Time, will be delivered next week, next Monday, by Professor Robert Kinsman of the English Department. Until then, good night.